on the theme of the discussion. So I start from there. We have Srimati Ashani. She is an IPS officer of 2001 batch from Odisha cadre, and currently she has been serving as IGP training in Odisha. We are thankful to her that she has come all the way from Odisha to join this panel with us. Next to her is Shri K. Ramanujam sir. Is a 1978 batch IPS officer who retired as DGP Tamil Nadu. So thank you so much, sir, for coming all the way from Tamil Nadu to join this discussion. To my left, we have Shri Kepi Singh, whom you have already seen. Sir is 1985 batch IPS officer from Haryana cadre, and sir retired as DGP Haryana. Then we are fortunate to have Professor Dr. Nuzhat Praveen Khan with us. She is a professor in Jamia Millia Islamia University, we all know. She was also former Dean Faculty of Law. So we have a very distinguished panel with us. And as I said in my introduction, straight away, I may request the panelists to be ready with their opening remarks. And I think, shall we begin with you, ma'am, if it is okay with you? Yeah, because let's have the viewpoint of the academia first before I come to the police officers. So I will request you to kindly give your opening remarks on the new criminal laws. Thank you.
Thank you so much for giving me this opportunity. However, I'm generally audible to all the students.
Ma'am, please put it on.
I don't know.
Yeah, it is on.
Good afternoon, everyone, and thank you for holding here after lunch, which is a very difficult thing. However, today we all are gathered here to ponder upon a very important subject, which is, all of us are very curious to know and to understand. And I'll not say I'm that much an expert, but still, being a teacher, I may be able to put some light and to share some of my thoughts on the subject. So as already Professor Jain said, we already have the introduction of the subject, that this law came into existence, there are 3 steps. First, the bill came in August 2023, then it was enacted or passed by the Parliament in December, 25 December 2023, and then finally got implemented on 1st of July 2024. And implementation means a lot, actually. Now this requires to be known to with all the stakeholders, whether it is judiciary or police officers, or even for the student. This is for the first time they will have their semester exam coming in December from this particular new law, which is called as Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Saksh Sanhita. So these 3 laws, they have, have been overhauled. There are very many welcome changes, and it is basically to effectively and in a very big manner to overhaul the subject, keeping in view the time. That was a very old law. I'll not say anything about colonial or something, but everything requires innovation. Everything requires to be with time, I'll say. So keeping in view that the requirement of the time, lots of digital technology, electronics, and forensics, which has with the time passed, requires the new type of dealing with the criminal justice system. So how we have this particular law, which is quite taken care of all the things. There may be people who can criticize, but everything have some or the other type of maybe lacunas or maybe certain suggestions which can be taken care in the passage of time. So if you look at the, if you talk of Bharatiya Nyaya Sanhita, that is somehow the new penal code, you will say. It has, one thing, it has reduced the number of sections. Earlier we were having, in the books you were seeing 511, and then with amendments A, and B, it was around 576. Now it has come to only 356 or 58. So that is a, a huge relief for the people that the number of such sections reduced. Then it is, it has clubbed certain things. Like, for example, which I think I'll speak in the next round, I'll be speaking on the topic offenses against women and children. So this, otherwise in the IPC, that was now Bharatiya Nyaya Sanhita, in IPC, the offenses were scattered throughout the IPC. They were not placed at one place. In the Bharatiya Nyaya Sanhita, it is a very significant and welcome change that they have clubbed all the offenses relating to women and children confined to one chapter, which is chapter 5 of the Bharatiya Nyaya Sanhita. So in this one chapter, very exhaustively you can see the offenses which are against women and children. Then, apart from, this thing, this is the first chapter in the sense when offenses begin, because before this, the other 4 chapters are, one is definitions, then second is with regard to punishments, then general explanations, and then conspiracy and abatement, etc. But if we look at the exactly offenses, so this is given preference or over even the body offenses, which those who are the law students, especially, I can see many students, you can see the offenses against human body was the most important chapter in the IPC. Now, if you look at the preference order of the chapters, you yourself will feel that how much importance has been given for the safety and security of the women and children. So how this chapter has been made a very important chapter. There are many other changes which are very welcome changes in the criminal laws, especially if I talk of BNS. There are, organized crime concept has been there. New offenses have been added. It is related to in property offenses also, even in body offenses, even in the chapter 5, which is offense against women and children. So I think students and all the police officers, they will also take note of that offenses against women and children have been given quite a prominent place, and it has given a very significant importance, which otherwise I understand was being ignored, was not taken, maybe because we are a patriarchal society, maybe even certain definitions which I'll talk, they have been quite considerably have been changed. And one thing which I'd like to point out, while we are saying number of sections have been reduced, here is a point which students should take note, that earlier the definition clause in the IPC was scattered up to section 53A. And now, just like other Bayer Acts, if you see the Bayer Acts, first section is generally about the extent and commencement of the law, and then the second section generally talks about it's a type of glossary, or you can say that's the interpretation clause, and you see the definitions. So now this is a very welcome change. They have put all the definitions in section 2, just like the other laws. And some of the definitions which have been added, I'll talk later on. Thank you.
Thank you.
Good afternoon, ladies and gentlemen. I'll talk about the provisions which need revisit, where I think the social ethos have been slightly not considered, and the legislature has gone even beyond the directions of the Supreme Court. I'll begin with the loaded statement that this law is very progressive and futuristic. Now let me come to those provisions which need revisit. First of all is section 377 IPC. In Navtesh Johar, the Supreme Court did not struck down the complete section. It saved 2 provisions, bestiality and forced unnatural offense. But while decriminalizing 377, we have left 2 types of victims with no remedy: transgenders and adult male who are forced to undergo unnatural offenses, they have no remedy in law. So I think it is a provision where we need to rethink, and Delhi High Court has already taken cognizance of this matter and issued notices. The second provision is section 497 IPC, adultery. It has been removed from the statute book. After the judgment of the Supreme Court in Joseph Sign, this offense was struck down from the IPC. But the Supreme Court erred on 2 points. One, there was the concept of inequality in the provision. The Supreme Court have very well made it gender neutral so that that equality clause should have been protected there. Second is the second part of this section, which provides that a woman can have relationship with a man outside marriage with the consent of her husband. The learned judges failed to understand what was the meaning of that section. The meaning of this provision was niyog. How Pandavas were born, we all know. And that was the custom at that point of time, traditions in 1861 when IPC was written, and the British, they protected it. But our judgment, our Supreme Court failed to understand that and completely struck down. I do not advocate that niyog should be reintroduced, but at least the provision of marriage should have been protected by retaining section 497. Because the chapter under which section 497 is listed, the title of the chapter is of offenses against marriage. The idea was to protect the institution of marriage, because it is the institution of marriage which has been the cornerstone of our civilization, and we boast that we have been the oldest civilization basically because of the institution of marriage and family. So this is the provision which need revisit. Most of you are law student here. There is a presumption in law that a child born within 27 years of even after dissolution of marriage shall be presumed to be a legitimate child. That is the sanctity of marriage. It needs to be protected. The third is decriminalization of section 309 IPC, that is amend to commit suicide. Welcome step. But the remedy was available under section 1151 of the Mental Health Care Act 2017, whereby it is provided that a person who attempt to commit suicide should not be prosecuted and punished. He should be treated as a psychiatric patient. But how will come to know that such a person exists when we do not even document it in the form of FIR? So the best way would have been to transport those provisions as an explanation in section 309 and rewrite it. The next provision is maximum period of under trial which can remain in jail. Here in the morning session also somebody commented it's a very welcome step. But if you read between the line, you will see that not even a single person will be eligible to avail the benefit of this provision. Why? Because they have said that if a person is charged with more than one of offenses, even in a single FIR, he will be ineligible. And as police officer will know, in 95% of the cases, there are more than one section in FIR. Second, if there is more than one case, he will be ineligible. Secondly, they have expanded the sections where the person will not be able to avail this right. Even life imprisonment has been added in that list. Earlier, it was only death penalty. The provision, another provision which I will mention in brief is community policing. They have introduced, but with no modality. In field, there is confusion who will execute this sentence, whether jail authorities or they will create some other authority. Who will supervise these community policing services? There is no modality involved. So modality should have been spelled out. Plea bargaining in the morning session was also referred. It is a dead horse. I have not seen even a single case in the last 15 years after this provision was introduced in CRPC that a case has been plea bargained. And same is going to happen now because we have not changed anything substantial in it except minor changes, cosmetic changes. Witness protection scheme we have already mentioned. Whereas in Mahendra Chawla, the Supreme Court has given the whole scheme, how you should go about it, but we forgot to give the detail in the CRPC. There are many drafting mistakes, which in discussion when it will come, we will go there. But I conclude with saying that there are many positives, but there are certain lacunae also where we should concentrate and revisit. Thank you.
Thank you, sir.
Good afternoon, everyone. It is less than 100 days since we sang the requiem for the old criminal major acts. The new acts have come into place in the spirit of what Lord Tennyson wrote, the old order changeth, yielding place to new, lest one good custom should corrupt the world. Maybe the old acts were one good custom, but then they had to go. As is to be expected, there have been bouquets and there have been brickbats, and the heaviest brickbatting has come from civil rights groups, human rights groups, and to some extent from the bar also. Now I'm going to present the point of view of these quarters. These are not exactly my views. I'm just presenting what others have expressed. I will outline the objections of these groups. In fact, if you see the number of changes that have been effected or new introductions that have been made are quite few, not too many. But still, some of these groups have made so much noise as if this entire thing will is aimed at arming the state with untrammeled and uncontrolled powers. So their objections I'll outline under 4 heads. As I said, these are not my views, and the individual points can be discussed. And since the time given for opening remarks is only 5 minutes, I will not go into the details on everything. These can be reserved for discussions and interactions. The first point that is made is there is an attempt to criminalize democratic and peaceful expressions of dissent and protest. This is one of the first major attacks. They refer to 3 particular sections in this regard. One is section 113 of BNS, the second is section 152 of BNS, and the third is section 226 of BNS. Section 113 of BNS deals with terrorist acts. The main criticism is there's already an Unlawful Activities Prevention Act which defines terrorist act in exactly the same manner as it is given in BNS. So why have this UAPA? Why have this section in BNS? Especially when you don't have the safeguards that are provided in section 45 of the UAPA. There are 2 important safeguards there which do not find place in BNS. In fact, some people have seen even a conspiracy in the way this section has been placed. This section has been placed in the chapter on offenses against human body. And why should it be an offense against the human body? It should be, in fact, an offense against the state. What these people see is that if it had been placed in the chapter on offenses against human body, then under section 227 of the 217 of the BNSS, previous sanction of the government would have been required for prosecuting these cases. So they see a deliberate attempt to place this section in this particular chapter on offenses against the human body. The second point in this regard about criminalizing democratic and peaceful protests is about the introduction of 152 IPC. Now 124A IPC, 152 BNS. Now 124A IPC was put on hold by the Supreme Court in 2022 with little chance of resuscitation. Now, this new section 152, which deals with acts against endangering unity, integrity, and sovereignty of India, some people regard that it is a new avatar of 124A. That is not exactly correct. We can discuss it later. And the third section, which they think is an attack on democratic protest, is section 226 BNS, which is about attempt to commit suicide. In this, so suicide as an offense has been removed, but an attempt to commit suicide in order to force the hands of a public servant is considered an offense. Now, there is an apprehension that this can be used for a clamp down on democratic protests in the form of hunger strikes. So these are the three major points on which there is criticism on this particular head. The second criticism is about eroding the rights of those who are in conflict with law. The following are the major criticisms under this head. I will not go into the details. Maybe some of them can be discussed later. One, handcuffing. Number two, extension of the duration of police custody. Number three, digital display of information about arrested persons. Number four, trial through video conferencing. Number five, trial in absentia of proclaimed offenders. Then permission to attach property by ex parte orders. And finally, getting samples of signatures, handwriting, and voice recording, even from persons who have not been arrested. Now, as police officers, many of us will be surprised that there could be objection to many of these features. In fact, these many of us would regard as helping the investigation and trial. But then, these are the views from the other side of the fence. The third criticism is that there is a raw deal given to the complainant. Two aspects can be mentioned. One is the provision for preliminary inquiry when a complaint is given, when the punishment is between 3 years and 7 years. Obviously, there is an apprehension that this will result in delay, either delay in registration of case or even denial of registration of a case. And this particular section, this particular provision for preliminary inquiry is violative of the Supreme Court guideline that preliminary inquiry can be done only to verify whether a cognizable offense is made out or not if the complaint itself is not clear. Whereas here they are talking about a preliminary inquiry to find out if there is a prima facie case. So this is one objection. Second point in which a complainant could face problem is about complaints against public servants. Now, this new law requires that if there is a complaint against a public servant which is filed as a private complaint before a magistrate, then the accused public servant is to be given an opportunity to explain, and further action cannot be taken without getting a report from a superior officer. So this practically gives, this is the view of the human rights and civil rights groups, that this kind of gives an immunity to public servants to even act with impunity, because it's not likely that any public servant is going to admit that what he has done is wrong, and it is very rarely that a superior officer is going to say what his subordinate has done is wrong. The fourth point is the state and the police are seen as acquiring draconian powers under the new laws to the detriment of the citizens. One instance cited, a petty instance, but still an instance cited, is section 172 of BNSS, which says, all persons shall conform to lawful directions of police officers, and that on refusal they may be removed or detained. This is a new provision in BNSS. And those earlier sections which I mentioned, which are supposed to erode or curtail the rights of the accused, are seen as increasing the authority of the police correspondingly. Finally, I would like to touch upon the point Mr. K.P. Singh made about adultery. Not many will know that when the IPC was drafted by the first law commission headed by Macaulay, they also published notes to go along with the IPC sections. Not many people would have been able to read the notes. We have read only the sections. Now, this particular report has devoted 4 pages to the topic of adultery to discuss what should be done, what should be the approach. And at the end of the 4 pages, they say, we think it best to treat adultery merely as a civil injury, because they didn't want the government to enter into matrimonial matters. For some reason, this was not accepted by the then government. The British were in power. I'm talking about in 1860. So when the new law actually came into effect in 1860, adultery was made an offense. But now adultery has come a full circle when it has been decriminalized by the Supreme Court. This took 160 years. Now, whether we agree with the decriminalization or not, the point is there are certain concerns that have been expressed, and we need not wait for 160 years to take note of the feedback. We should approach these criticisms in the spirit of appreciating the constructive and ignoring the destructive, and make changes as may be in the that are in the best interest of the state and its citizens. Thank you.
Distinguished panel members, panelists, senior officers, all the people who are patiently listening after a sumptuous lunch. I would like to, because we are running short of time, I would like to specifically point out certain things with the objective of having the scope for improvement in case the government is considering any amendments or any rules in pursuance to the new enactments, which, as has been told, also contains a lot of progressive provisions. I will come straight to things that an ordinary man would encounter when going to a police station. As you all know, a FIR is recorded under section 173 of BNSS. Now, from the point of view of a normal person, they go to the police station to register an FIR. So this was an opportunity that we missed by changing the language in the law, to bridge the gap between the language used in the law and what as it is understood by ordinary people and also the police. We refer to registration of FIR, but there is no registration of FIR in the BNSS. So 173 speaks of recording of cognizable information that a police station receives. Now, when it is received, what the officer in charge is expected to do is recording is by process of entering the substance of that information into a book, which has been now settled to be the FIR. It's known to everybody that there is no book as such at present, which is the FIR book, which once upon a time the police stations had a book, which was the FIR book. So we have probably forgotten at the time of this legislative change that it's now a form as prescribed by the state government, but that form is not in the form of a book, but in the form of CCTNS entry in the computer. So this was something that we could have taken care of by bringing in what we ordinarily use, FIR registration. Neither the FIR is in the word first information report is there in the law, nor is the word registration of FIR. So these are two distinct things. Recording of information, if it is received oral information, written information, or electronic information has to be reduced in the form of a book. Now coming to the change that has happened in BNSS, there is something called as a zero FIR, which a lot of people have referred to in the morning, which is a very good thing. You have heard of the case which was referred to by the law minister regarding the train journey and refusal to register the FIR. It's good that the provision of zero FIR has come. But what about certain offenses where a rape victim is found in another jurisdiction? You have to do the medical examination. You have to take a statement. What if the victim is very severely injured? A dying declaration may have to be recorded. So these preliminary steps in investigation do not at present have the sanctity of law. Whereas a lot of SOPs have come which said that you can assign and investigate. In fact, in the zero FIR form, there is an option where you can assign an IO, but some of the state SOPs say that you cannot entrust an IO. Some of the state SOPs that have come up say that you can entrust an IO in cases, but whose discretion that is, whether to assign an IO or not. You are leaving it to an officer in charge decision and discretion, and there is no legal sanctity to those initial preliminary steps. So by introducing a zero FIR, we could have as well thought of legal backing to the steps that are immediately taken. Maybe an accused is being brought by somebody, so his arrest has to be recorded. Would he be produced if the offense has happened in a place which is far away and you are getting an accused in a case and the FIR is also registered in that police station? What would be the initial steps that is expected to be taken at the police station? Second, there is also a lot of confusion between when a zero FIR is registered at present, this doesn't go into the chronological sequence of FIRs in the police station. It goes into a different chronological sequence. And this decision to transfer the FIR to the actual police station where the territorial jurisdiction of the offense lies, at that end police station, what will you do? Whether to, if it is a PE case, whether you can conduct a PE, or whether you are mandated to re-register it as an FIR. So this also again, the BPRND SOP says that the destination police station has no option but to register the FIR. But there are many state SOPs which say the contrary, that officer in charge at the destination police station, receiving police station, has an option whether to register the FIR or to register a PE. I also would like to point out another very nuance in the law, because I do not want to cover the practical aspects. 173 says that every cognizable information that comes to the police station has to be recorded in a book, which is the FIR. What about PE? 173(3) provision, the legal provision, is without prejudice to the powers of investigation under 175. Now, there is no prejudice to the power of the officer in charge to proceed to investigate a cognizable offense, but it is not without prejudice to the provision in 173(1) which says that any information comes has to be entered in a book. So whether preliminary inquiry is a pre-FIR process or a post-FIR process, there is a legal nuance in it. I hope you are getting the point that 173(3), which says about discretion of the officer in charge to enter into a preliminary inquiry in cases where punishment is 3 to 7 years. In those cases, legally, as far as I have understood the provision, there is nothing that exempts the mandatory provision in 173(1) which says that every cognizable information that comes has to be entered as an FIR. So I think this needs to be resolved. I would also like to say about what I'm trying to say is that strict interpretation of law, there cannot be a preliminary inquiry without registration of an FIR. And if police officers have been authorized to also, under Chapter 13, not only to investigate but also to inquire, then there should have been powers of police officer to investigate and inquire. Powers of both should have been covered in the subsequent provision of legal empowerment. And coming to the inquiry, what is the scope of the inquiry? As was discussed, the inquiry is to ascertain, not like what was in Lalita Kumari, to see whether there is a cognizable offense made out or not. The inquiry is to ascertain whether a prima facie case exists or not. It's not very easy thing. It evolves whether you can examine. There is no clarity at present as to whether during the process of inquiry, I can visit the spot, whether the investigating officer can seize certain objects, whether the investigating officer can examine witnesses, and how would you record it? These are things that I think, because there is no detailing as to what should be the inquiry and how this inquiry will be conducted. These have been covered in SOPs, but then there is no legal backup for the SOPs that have been issued both by BPRND and the states.
Can we take the remaining points in discussion?
Sir. Sir. Thank you.
Thank you, the panelists, for giving the opening remarks. I'll come back to Professor Nuja, because you have already given us the salient changes that have been made in the Bharatiya Nyaya Samhita. And I'd like to ask you one particular question. Rather, I'll request you to elaborate on that. We know this new section 69 has been added, which makes certain offenses relating to sexual intercourse with a woman. And one of the new offense that has been added in this section is that if you have sexual intercourse with a woman on the pretext of marriage, false pretext of marriage, false promise of marriage, then you can be booked in this offense, and the punishment is also very severe, 10 years. So I think there is a concern in the civil society on this, that we know that in many cases, particularly when people are in courtship or people are in living in relationship, and tomorrow they may change their mind, they may not decide not to marry because they may not find themselves compatible with each other. So whether because of this new offense introduced in the BNS, there will be a misuse by people who are kind of, like can subject this to misuse or abuse. So what are your thoughts on that, and I mean, for the investigators also, what would be exactly the kind of evidence demanded by this section to prove the ingredients of this particular offense? So I would particularly request you to touch upon this in your discussion.
Thank you. Thank you for the question. And regarding the topic which actually I'm speaking is about the same actually, which is actually one of the unique feature of this Sanhita to incorporate all the offense against women and child. You asked about 69, but if I begin with section 63, actually this whole chapter, which is chapter 5, is clubbed into section 63 to section 99. Which is all about the offenses against women and children. So if we look at the first section itself, which is section 63 and is a replica of section 375, which was the section for rape. And this section is having its language, which actually is somehow absolutely the same which was existing before. But all of you should know that 2013 Justice Verma Committee report has suggested some wordings, some of which have been incorporated into it. And most important change is with regard to the language and the consent word in the definition of rape. As well as if we look at clause 2, if you have the definition, somebody in front of you, you can see that they have, apart from the, that natural way of committing a rape, they have also included clause 2, which was talking about, it's because it was after Nirbhaya, gang rape case, and they noticed how brutally that lady was assaulted. Sexually assaulted. So they have included any object also into the definition. However, I think it is not taken cognizance by anybody, including judiciary. You see that some word, have you heard about this word digital rape? Any one of you ever? Don't confuse it with the cyber word. It is nothing to do with the cyber word. It is not, because the moment we see any term which is digital, we just conclude it something happening by way of technology, something happening by way of computers or internet or some fake identity or somebody doing something. But no, it is not actually. It is a type of finger rape. It is a type of sexual assault of a woman through any other object, and that is very specifically have been given. But I'm sure even if somebody comes objecting and giving a complaint about that I have been raped, but it was this method, then the person's, maybe that complaint may not be taken in that form. So it really needs sensitization. This gender, this term which have been specifically given in clause 2, and apart from that, the two exceptions of the definition of rape. If you look, the two exceptions, one is if somebody touches upon a woman with the intention of some medical procedure. Another is a husband into a sexual relationship with his wife will not be called as rape if the wife is above 18 years of age, which is quite objectionable, and most of you must be knowing, because the word consent they have already defined very elaborately. Consent, will, all the words have been, and consent have been so specifically, I will just read this word consent: an unequivocal voluntary agreement when the women by word, gestures, or any form of verbal or non-verbal communication communicates willingness to participate in that specific sexual act. So, and the age of consent, which was earlier 16 years, now has been raised to 18 years. But the question is not that. In fact, a case which is Independent Thoughts versus Union of India. It was in the High Court, and they it went to the Supreme Court now, whereby the question is not whether it is raised from 16 to 18 years. The question is, even a woman who is above 18 years of age and does not consent into the sexual relationship, even with her husband, it will amount to marital rape. And this term has been actually suggested many times, even the previous time, and right now, when we were entering into a new era in the form of BNS, which we feel is a very, it will be a very effective and efficient framework for addressing all sort of crimes. And we are talking about victim-centric justice, but it has not been taken care at all. Marital rape has not been taken care at all. We are just following. However, we know many of the countries across the world, they have come up with this law. They long back. And in our country also, the debate is going for long, but we have not addressed that. Second thing is, we have, on the one hand, we are talking about the gender-neutral offenses, gender-neutral crimes. We have also defined the term gender, transgender, in the definition clause of the BNS, where earlier it was male or female was defined, but today we have transgender. But unfortunately, there is no crime have been specified under the whole BNS, which is against the transgenders. And all of you must be knowing that we have a law also passed in 2019, which is about the rights of the transgenders. But in the criminal law, which is BNS, we have not addressed, there's no gender inclusivity. Though we want to make most of the laws as gender neutral. There are some whereby you will see in place of male, they have said whoever in the morning session, you might have noticed. I'll tell you further. And with regard to the section which the moderator just mentioned, it is about sexual assault by deceitful means, which is a newly added section of Bharatiya Nyaya Sanhita. In fact, it is a type of overlapping. If you read, section 63 itself, you will find the similar type of wordings in that section on false promise of marriage, and especially in this world where youngsters are here, they know there's lots of, culture of live-in relationship is going on, and later on the complaints of rape of the same sexual relationship, which was earlier maybe voluntary, but later on if it is without the consent and then it is coming. So the punishment is severe, but that's a welcome section. It should be actually interpreted positively, then it's a very good section. Also we have some more things which requires consideration apart from, taking, if you was at this point of time, you must have, that Justice Verma Committee report very specifically given good recommendations about the offenses against women, and your concern with regard to women and children offenses by putting them in a separate chapter, by organizing them in a manner. So I think that could have been taken into consideration, because very shortly we will be requiring these changes. The debate is already on. Again, after Verma Committee report, we had this section 354 in the IPC, which was about the outraging the modesty of the women. So in this, and then later on, A, B, C, D were added, which was about, voyeurism and other type of assault. So now they are, some of them, not all of them, they have become gender neutral. That's a good move. Others could have also been made gender neutral, but it is not. If you see section 77 BNS, which creates liability of a person irrespective of who the other side is. So this is the time we are talking about the gender neutrality even in other offenses also. Like we have sexual harassment of women at workplace law, which was also passed way back in 2013. It's a very gender-specific law, and some of the questions are already starting arising. Okay, a woman cannot harass a man, but can a woman harass a woman? So these are all changes which require and which is the need of the time. Then I'm just going on to give few more points which came to my mind. Yeah, you can. Thank you.
With respect to the ma'am's comment regarding sexual intercourse by deceitful means, a new section has been added. I find there are police officers also here. So one reason why 376, the ex-IPC section and rape as such was trivialized by police station people, where because there are substantial number of cases which are technical, because in police language we say that technical case, because there is actually a consent, but the woman reports a forceful intercourse after the marriage doesn't happen, or if there are issues in relationship later. So because of such overload of such, or like whatever number of such cases, there was an attitude of trivializing the actual reports, with a prima facie intention कि ये तो consent किया होगा. So to that extent, it's a welcome step that a new provision has been put where sexual intercourse by using deceitful means, false promise of marriage also comes under it. But I am just worried, ma'am, about the extent of punishment that has been given for it, which is up to 10 years. So it's a welcome in one way that there is a new provision, but then making it almost as severe as a rape would not serve that purpose. Thank you.
Thank you, Chani. Sir, I'll come back to you because you made a very interesting observation regarding the efficacy of this provision, which is advocated as a reformative provision in the new law, BNSS in particular, where they have reduced the period for which under trial prisoner can be detained in the prison. As we know, as per section this 479 of BNSS, if there is an under trial who is facing trial in the court, and if this person is a first time offender without any previous history of conviction, and if this person has undergone 1/3 of the maximum punishment under that particular section, then this person is entitled to be released on default bail, or released on bail by the court, and the onus of making the application is on the jail superintendent. So earlier this period was 1/2, it has been reduced to 1/3 for first time offenders without previous conviction. Now you say that this is going to remain on paper and it is not going to be of any help, because you say that those who are charged for more than one offense, then they will not be getting any benefit. But if we read the explanation 2 given in this 479, I'll read it for the benefit of audience what it says. Notwithstanding anything contained in subsection 1 and subject to the third proviso thereof, where an investigation, inquiry, or trial in more than one offense or in multiple cases are pending against a person, he shall not be released on bail by the court. In any case, what it means, someone who, in addition to this case under trial, if against the same person there is an under investigation matter or some other under trial matter, then in that case this person shall not be entitled to be released on bail. But in case there is no pending matter against this person, and this was the only pending trial against this, and he is a first time offender without previous conviction history, in that case I don't see there is any problem why this person shall not be released.
Please read subsection 2. It starts with non-abstante clause. Notwithstanding anything in subsection 1. Forget about what is said in subsection 1 and read this hereafter. The subject to the third proviso, where an investigation, inquiry, or trial is more than one offense, means in the same FIR there are more than one offense, or in multiple cases where more than one FIR is there pending against the person, he shall not be released on bail by the court. So what is the important thing? This non-abstante clause, notwithstanding, meaning thereby everything is washed off. Read this provision, it will prevail. Second objection is, yes, second objection is, earlier in 436A, only those who were facing penalty for an offense which was punishable with death, only they were denied this right. Now, They've also included life imprisonment in that. And in IPC, there are more than 100 sections where life imprisonment is the punishment. And all heinous offenses. 100, more than 100, read, sir. Right? More than 100. सर रेप में ही देख लीजिएगा 8-10 तो वहीं मिल जाएंगी. Yes, बहुत ज़्यादा है. So they are also not covered, meaning thereby all heinous offenders, they will not get this benefit. So they have expanded the scope of not giving the benefit further by increasing the number of sections. Secondly, by giving this caveat, notwithstanding Section 1, nobody will be released. So this was my observation, that somebody has very cleverly crafted it. Drafted it or crafted it, that nobody will be eligible. So when I was taking classes for jail superintendent on these topics, I told them, don't worry, nobody would be eligible by that time. So here we need some thought.
Sir, you have made a very valid point. I'll go to Ramanujam sir. In your opening remarks, you mentioned about, I think there is a concern from the human rights groups about the extension in the period of police custody. That is, you are talking about the new section 187 of PNSS. So if those of us who listened to the speech of the Honorable Home Minister on this particular section, he clarified, and I think in a subsequent press conference also, that as far as the total period of police custody is concerned, it has not been increased. Earlier also it was 15 days, and here also in the new provision it can't go more than 15 days. It can't exceed 15 days if we read carefully section 187 subsection 2. Then further it was clarified what we have changed is only the period up to which you can seek police custody remand, because those of us who will know, it was in this Supreme Court judgment in Anupam Kulkarni versus CBI in the year 1992 that the apex court held that once you arrest a person, then from the day of arrest, it is only up to the first 15 days that you can seek police custody remand. From the 16th day onwards, the custody could only be judicial custody. So keeping in view the practical difficulties the police were facing because of this ruling, what they've changed is that now this police custody remand of 15 days, you would be able to seek up to 40 days or 60 days depending upon the period of punishment of that offense in which that person is being investigated. So, I mean, after this clarification, so what are the concerns of the human rights groups, on what grounds they are thinking that this period of police custody can go beyond 15 days?
What is the clarification? I don't know the clarification.
No, clarification, they say, I'm talking of the law.
Now what does it say?
It says it can't exceed 15 days. So, we can read. We have the book.
I'll just read, I'll explain that. See, the basic problem here, what is being pointed out is that if you take section 167 of the CRPC, it says the magistrate may authorize detention beyond the period of 15 days, otherwise then in custody of the police. That particular portion has been taken away. So if you see this 187.3, it simply says, the magistrate may authorize the detention of the accused person beyond the period of 15 days if he is satisfied, etc., etc. Now it doesn't say what custody. So this could be interpreted to mean.
So there are issues of
that will be the issue. The second point is, one more point is, there is a lot of, there are different people have interpreted it in different ways. Some people say this allows maximum 15 days of custody anytime within the first 40 days or 60 days. Some people say it will allow police custody for the entire 40 to 60 days. Some people even go to the extent.
Because they say, sorry sir for this interruption, they say, like when we read this, not exceeding 15 days. For a term not exceeding 15 days. In subsection 2, it is made very clear, whatever custody they are mentioning in subsection 2 will not go more than 15 days. That is for sure.
Subsection 2 does not talk about police custody. It
Even
only,
that
it
is
only
what I'm
talks
saying,
about, yeah.
whatever custody, because it is this custody for which they have allowed you a period of 40 days or 60 days. But the period of the custody, we have to distinguish between two things here. Because the period of custody can't go more than 15 days is very clear. Though, of course, they don't mention police custody over here. That point is well taken. But whatever we interpret it to be, whether the judicial custody or police custody, it can't go for more than 15 days is very clear. What they say, they have increased the room, the number of days within which you can seek this police custody from the magistrate, this custody from the magistrate. One more observation, sir, I like to make for your consideration. In subsection 3, they say, not the custody in subsection 2. So the two custodies mentioned in subsection 2 and 3 have to be different. They can't be the same. Though it is a valid observation that they should have very clearly mentioned in subsection 2 the police custody word, and in subsection 3 otherwise than in police custody, as was the case before, then perhaps this confusion would have not arisen. But one thing we need to very clearly understand, the custody mentioned in subsection 2 and custody mentioned in subsection 3 can't be the same. It has to be different. So if we say in subsection 2 it is police custody, then in subsection 3 it has to be a custody other than police custody. By implication, that interpretation will hold good. It looks to me.
Yeah. That is the point. There is room for interpretation in different ways.
Room for improvement
See,
of language.
precisely. In fact, I would say this section may be redrafted. Another point I don't understand, why are they bringing in 40 days and 60 days? What is the logic? There is no logic at all. In fact,
there are concerns, sir, actually, I find.
yeah, I'll finish this. So my point of view is, when the police have 60 days or 90 days for investigation, they need the leeway to question the accused anytime during this period. Why restrict it to 40 days? Let them give 15 days custody anytime during the 60 days or 90 days. This can be, actually, as you said, it is bad drafting. In fact, I will...
Simple reading creates a contradiction.
Precisely. That is precisely the
Simple
point.
reading creates a contradiction.
Actually, there is a lot of problem in the way the drafting has taken place. Plenty of reason for confusion. For instance, if you take matching.
I think they should add our notes.
Pardon?
Yeah.
They should add some notes to clarify this.
To know the legislative intent.
Simply have to change language. That's all. Language.
Yes.
I would request everyone to speak
Yeah,
with the mic.
yeah, because we are broadcasting. Sorry, sir, you made the right observation. But I think this is a very interesting section 187, and there are a lot of observations, questions which may come. Let us, I think, reserve it for future. I'll move on to Shani for a question. I think I'd like you to address the concerns relating to sections 105 and 185 of the BNSS. We know in section 185, because I think the audience also need to know, if you ask anyone which is one section in the BNSS which enforces police accountability, means makes police more accountable than before, it is section 105 of the BNSS. What it says, that whenever police would conduct any search, like under this chapter, means after obtaining warrant, or under section 185 BNSS, that is without warrant, it will have to mandatorily, compulsorily do the video recording of the entire process of the search, including seizures, signing of the list by the witnesses, what articles police is taking away, etc., etc. So again, this has raised implementation concerns, particularly in the police, because at times these searches go on for many hours, done at multiple locations. Issues of storage are there, and the further provision in the same law says that the recording will have to be provided either to the district magistrate or SDM or the judicial magistrate of the first class, as the case may be. So how the police intends to handle these concerns, will you like to address?
So thank you, sir. This is one particular section and mandate which has made the lives of police officers very, very difficult, because 105 BNSS and 185 mandates mandatory, it's a shall provision where you are bound to video record. Audio video electronic means, it says. The problem, one is with respect to the practical implementation, for which we have a session, but by using language in the law, by audio video electronic means, and preferably by mobile phones, I think this should have been avoided, because we have been like talking of lot of nuances. I was just wondering if there is a scope for coming out with rules covering all the aspects that we are referring to, like in many countries, instead of going for, because there are a lot of nuances in PE, CROFR, lot of new things which have come, some of it are progressive, but like sitting on the dais, all of us have understood even the custody matter differently. So to leave out this, to avoid the scope of interpretation, is there any scope we can explore to come out with rules covering all the aspects? With respect to audio video electronic means, I would like to say, point out a confusion in law that is prevailing across. I think BPRND has also issued an SOP on audio video recording, which has been like mostly copied as such by the states with minor modifications. The SOP says when audio video recording of the search and seizure is being made by the police officer, who has to, at the scene of crime, do so many things: collect the evidence, take a statement, keep the accused under detention, and he is also now expected to record the thing. You are not giving an extra person to the police station, because this requires a lot of institutional capacity building, lot of SOPs have come saying that it's not clear as to whether the investigating officer should do it himself or whether somebody else, or he can get it recorded. Let us presume that somebody else can get it recorded. At the scene of crime, imagine a road accident. He would be like managing the crowd. There might be a rastarogo at the scene of crime. The existing 3 or 4 people with whom he is going to the scene of crime itself is too less. Second, let me come back to the law, where in most of the SOP says after the audio video recording, it should be a certificate under 63 BSA should be given. I think when I read, we have to distinguish between procedural compliances, which I find in 105 and 185, it is a procedural compliance to bring accountability of police actions. We are not treating those audio video recording as electronic evidence. So 63 BSA is about admissibility of electronic evidence. So I think there is a misunderstanding, interpretation mistake, where we think that in audio video recording there should be a certificate under 63A and B. How many audio part A and part B certificates you would require? Because there will be so many. In a single case there will be.
No, this is wrong. This is a wrong interpretation.
No, what she's saying, please appreciate.
This is a wrong interpretation.
People are interpreting that way.
What I'm trying to say is, it's not required is what I'm trying to say, but already SOPs are issued which says, including the BPRND SOP, which says that that certificate is mandatory. And in the BPRND SOP, Part B certificate, there is a small box given, and it very specifically says Part B has to be signed by the forensic expert. Jain sir has already raised the issue of the expert. I'll not get into it. But what about Part A certificate? Part A. Now we'll go on to the certificate portion. Part A says about hash value and the algorithm used for hashing, for coming out with the hash value. Now we are thinking of a person sitting, giving us a CDR or big things when we are reading that. What about a jewelry shop fellow or a small Dukani fellows from whose computer you actually have to seize an electronic evidence? Will he understand what hash value is? Will he understand the kind of algorithm used? Now there is a legal mandate for that person who is handing over the electronic evidence to you to indicate the hash value and to indicate the algorithm used. I think we need to there is a requirement to revisit that provision. Thank you, sir.
Thank you, Shani. I think keeping in view the paucity of time, we need to now throw open the floor for discussion. We can take a couple of questions. I'll request people who are helping us to provide mics to the audience. Can we have some mics, please? Yeah. So otherwise we can take from here in case it is not there. So I think Ashish sir raised his hand, so I'll request him to make his observation. Yeah.
Thank you, Mr. Jain, for the opportunity here, and thank you for the panelists for wonderful observations that you have made on the BNSS, BSA, and the BNS. Shani, just to tell you, in UP, we did realize that the SOPs don't have the weight of law, so therefore we have come about with the Uttar Pradesh BNSS rules 2024, which covers all these aspects that you have mentioned. So it brings a bit of a legality to the whole thing. And you are right, I think we need to actually now come out with the rules also with the BNSS, all that. A question I want to throw up to the panelists, because I am a bit confused about this. There was this section 164 in the CRPC earlier, where a metropolitan or a judicial magistrate could record the confession. Now the equivalent section in the BNSS is 183. And interestingly, it says any magistrate of the district. So I'm confused. Does this give the right to record confession to even an executive magistrate of the district? And if that be so, it is pretty draconian. It's pretty draconian.
No. I think, is there anyone in the audience who like says that no, here when they say magistrate, it can't be executive magistrate. It has to be a judicial magistrate only. Yes, please. Yes, yeah, from that side. Can we pass on the mic to the lady, please? Because that has been clarified in certain parts of the BNSS. Someone needs to refer to that. Yeah. An executive magistrate won't be able to record, as far as I understand. No, 183.
सर जहाँ पे जुडिशल मजिस्ट्रेट की बात मतलब मजिस्ट्रेट की बात की गई वहाँ पे जुडिशल मजिस्ट्रेट ही है और जहाँ पे एग्जीक्यूटिव होगा वहाँ पे स्पेसिफिकली लिखा हुआ है.
हाँ, ये कहाँ पे लिखा हुआ है? ये चीज भी कहीं लिखी हुई है?
यस मैं
सेक्शन 3 में लिखी हुई है.
यस सर.
सेक्शन 3 अगर आप पढ़ेंगे BNSS का, वहाँ
yes,
पे इस चीज को क्लैरिफाई किया गया है कि जहाँ मजिस्ट्रेट अगर जुडिशियल मजिस्ट्रेट नहीं लिखा है तो भी वो जुडिशियल मजिस्ट्रेट ही माना जाएगा. अगर उस काम को एग्जीक्यूटिव मजिस्ट्रेट से कराना है तो हम स्पेसिफिकली लिखेंगे, तभी एग्जीक्यूटिव मजिस्ट्रेट उस काम को कर पाएगा. ये क्लैरिफिकेशन सेक्शन 3 में मिलेगा. दूसरा फर्स्ट शेड्यूल में भी मिलेगा आपको. वहाँ पे भी उन्होंने थोड़ा सा लिखा है, अगर हम शेड्यूल पढ़ेंगे, कि जहाँ हम केवल मजिस्ट्रेट की बात कर रहे हैं वहाँ जब तक हम स्पेसिफिकली नहीं बोलेंगे हम उसको जुडिशियल मजिस्ट्रेट ही पढ़ेंगे. ये दो क्लैरिफिकेशंस आपको BNSS में मिलेंगे. कन्फेशन नहीं, वो केवल एक ही पावर है सर, एग्जीक्यूटिव मजिस्ट्रेट को जो लिखा हुआ भी है. अगर आपको पुलिस कस्टडी रिमांड चाहिए किसी का तो 7 डेज तक का एग्जीक्यूटिव मजिस्ट्रेट दे सकता है. वो है क्लियर. यस सर.
Actually, this, I think you referred to section 3 only. It's very clear, unless the context otherwise requires any reference in any law to a magistrate without any qualifying words, magistrate of the first class or a magistrate of the second class shall, in relation to that area, be construed as a reference to a judicial magistrate of the first class or judicial magistrate of the second class, as the case may be, exercising jurisdiction in that area. In fact, somebody else had raised this point during our discussion in this internal reforms also, because original CRPC amendment said when there is a death in police custody, the inquiry shall be conducted by a judicial magistrate. Whereas the BNSS omits that word judicial, so they said executive magistrate can also conduct the inquiry. But I pointed out that if you read it along with section 3, it has to be a judicial magistrate.
सर एक क्वेश्चन पूछना था मुझे.
हाँ जी, कौन? पूछिए पूछिए प्लीज. आप जरा.
सब इंस्पेक्टर मनीषा,
दिल्ली पुलिस.
यस सर.
हाँ जी, बताइए.
सर जो सेक्शन 185 है, सर्च बाय पुलिस ऑफिसर, सर उसमें जो सेक्शन सब सेक्शन 5 है उसमें दे रखा है कॉपी ऑफ एनी रिकॉर्ड्स मेड अंडर सब सेक्शन 1 एंड सब सेक्शन 3 सेल फोर्थ विद बट लेटर नोट देन 48 आवर्स. सर इसका मतलब ये है कि रिकॉर्ड जो हमें भेजना होगा मजिस्ट्रेट के पास, जो उसमें क्या केस डायरी भी जाएगी, जैसे रिकॉर्डिंग है या जैसे हमने डोज नाम से डीडी एंट्री करी है कि हमें क्या सर्च करना है, तो क्या केस डायरी भी देनी होगी वहाँ पे?
ओके, गुड क्वेश्चन. ये सेक्शन क्या है 185?
सर्च बाय
ये
पुलिस
सर्च
ऑफिसर.
बाय ए पुलिस ऑफिसर विदाउट वारंट.
यस सर.
ठीक है. तो ये क्या कह रहा है, जो आपने चीज़ें सीज की है सर्च में, जो रिकॉर्ड आप लेके आए हैं, उसकी कॉपी या ओरिजिनल जो भी है वो आपको मजिस्ट्रेट को देना है। हम लोग अभी भी ऐसे ही करते हैं 165 में, देयर इज नॉट मच ऑफ डिफरेंस बिटवीन
सर, इसमें
165 एंड
ये
185।
जो केस डायरी वाला सेक्शन, ये जो नया
उसको
वर्ड
देखिए, केस डायरी से कंफ्यूज मत करिए। वो क्या लिख रहे हैं, पहले क्या था, इफ़ यू कंपेयर 165 एंड 185, पहले भी ये लिखा हुआ था कि ओनली व्हेन देयर आर एक्सेप्शनल सर्कमस्टांसेस, मीनिंग देयर बाय कि अगर आप कोर्ट से वारंट नहीं ले सकते, आपको लगता है कि जितना समय हम वारंट लेने में लगाएंगे तब तक तो ये जो हम जिस चीज़ को सीज करना चाहते हैं वो खुर्द-बुर्द हो जाएगी, तो इसलिए हमें पावर दिया हुआ है टू कलेक्ट एविडेंस एंड कंडक्ट सर्च इवन विदाउट वारंट। तो पहले ये था कि ये जो रीज़न है कि वाई डू यू वांट टू कंडक्ट सर्च विदाउट टेकिंग ए वारंट, ये कहाँ लिखना है, किस डॉक्यूमेंट में यू हैव टू रिकॉर्ड दिस रीज़न वाज नॉट स्पेसिफाइड इन सेक्शन 165। अब 185 में उसको क्लियर कर दिया कि आप केस डायरी में ये रीज़न रिकॉर्ड करेंगे। मजिस्ट्रेट को अगर देखना होगा कि वेदर दे वर जस्टिफाइबल ग्राउंड्स और नॉट फॉर डूइंग द सर्च विदाउट वारंट, तो आपको केस डायरी मजिस्ट्रेट को दिखानी होगी, कोर्ट को दिखानी होगी। वो जो नीचे वाला जो सबसेक्शन है 5 जिसकी आप बात कर रहे हैं, वो केस डायरी को कवर नहीं करता है ना। उसमें तो जो आप चीज़ लेके आए हो सर्च के दौरान, जो भी रिकॉर्ड लेके आए हो, डॉक्यूमेंट लेके आए हो, कोई मटेरियल थिंग लेके आए हो, उसकी कॉपी जो भी आपने सीजर मीमो बनाया है और जो भी कोई आर्टिकल सीज किए, दैट थिंग, दैट रिकॉर्ड यू विल हैव टू प्रोड्यूस टू द मजिस्ट्रेट। फिर क्या होता है, मजिस्ट्रेट से ऑथराइजेशन लेते हैं कि आई वांट टू कीप दिस थिंग्स फॉर द पर्पज ऑफ investigation, otherwise whatever you have seized from during search becomes the case property, the court property। तो उस चीज़ को क्लैरिफाई किया है।
थैंक यू
सर।
No, Dr. Nuzhat started off just explaining very briefly about the crimes against women and children, which have been combined. That's a welcome step. And the age of 18 years also is a very big step from our angle, who work for the children. Now, but then there are contradictions. I mean, the challenges are endless so far as children are concerned, more than women. See, there is the Juvenile Justice Act is a separate system of law and justice, all of us know. There are bodies like Juvenile Justice Board, Child Welfare Committee, District Child Protection Unit, Children's Court. They are all bodies which operate under JJ system, and there is no reference to them. There is a big problem. There is no reference to all these competent authorities, all these statutory bodies which are there, functional, and they deal with the children, whether the children happen to be victim or they happen to be children in need of care and protection, or they happen to be juveniles. You understand? Just one small point.
Yeah, you are right.
Now, the point I am trying to make that Child and Adolescent Labor Prohibition Regulation Act, the definition of adolescent has been brought equal to child, 18 years, isn't it? It's good that marital rape goes up to 18 years because, again, according to child. The issue I am trying to raise that POCSO, the child labor laws, child adolescent labor laws, all these Juvenile Justice Act, all of them create series of crimes. Many crimes are there. And you know, surprisingly, we have been asking for it, no amendment is made. There are offenses under JJ Act which have been declared non-cognizable, although the punishment is more than 3 years. And then non-cognizable and police not registering cases. The offenses against Child Labor Act, which are the police is not investigating those cases. Those things had to be rationalized and kind of brought together, at least interpretation, which is not there.
Absolutely agree with you. There are different sections here where they have created some minor changes, such as earlier the term minor was there, now they are saying child, and child means anybody who is less than 18 years or up to 18 years of age. So first of all, the definition of the word child have been taken care. Yeah, yeah. But with regard to, as you are saying, with regard to Juvenile Justice Act and all the, the authorities, all the, organizations which are taking care of the children's issues, there's no mention of it anywhere. There's no coordination, you will say. Even the POCSO Act, which already talked about the term sexual assault and grievous and heinous sexual assault, it has not been taken care here. So that's a,
Gender neutrality was brought in POCSO.
yeah.
And the Justice Verma committee, we appeared. I also
Yes,
appeared.
there is gender neutrality, but here
There
there's no
it could be extended to adults also.
Of
And the
course.
problem of 377 could have been sorted out.
Right.
But it was not done.
It
Even
is
now,
not
it is
there.
not done.
No, and even regarding what you are saying, up to 18 years of age and marital rape and above 18, and a question which was put by the moderator with regard to deceitful means. In fact, even the judicial, if you look at the way the society and the way the system deals with it, despite having a constitution which talks about equality before the laws and equal protection and having ratifying many of the international conventions, including CEDAW. But when we see some of the judgments, which I have not named at that time, there are few judgments where the judges themselves say the person who has done some sexual assault or rape, marry, and then the offense will be over. So that's the attitude which is there in the system. We need to actually address these issues very seriously.
Community service was there in JJ Act.
Yeah, yeah.
And
Community,
it has been
not
tested
only
already.
there, community surveys actually some of the judges are already using, and when we talk of restorative justice, and if you recall, if I'll given an opportunity by the moderator, if you watch one very old movie, Dushman, you will see the judge how beautifully put the hero on the community service, serving the family whose bread earner's death is caused, maybe, yeah, Rajesh Khanna. So community service is something, obviously to put the person on the correct side. The community service now, other issues, because they put in the law book in the form of one of the punishment, now how it will be checked, how it will be taken care, who will, how it will be given, and who will be monitoring, and all those issues are going on.
One small point, just one sentence.
Yeah.
That generally it's believed that the changes, the actual changes minus the changes brought because of court rulings is just about 7 to 8%. The changes are very little in the overall scheme of things, because the architecture of the criminal justice system, which includes police and jail, was left untouched, rightly mentioned by Mr. Prakashing in the morning. So unless you change the architecture, the change in law is very, very difficult. That's the feeling. Okay, thank you.
I think I'm very positive and optimistic. Maybe slowly, gradually, when the things will be addressed, will be taken care, and the things will be all right suddenly.
Yeah,
Thank you.
sorry.
Just a minute, I think can we give a preference to the students?
I just have a question in continuation with this. So firstly, of course, this is very kind of connected with what Mr. Kant said, and also what you had mentioned earlier about transgender, because the whole status and definition of transgender, especially children, has changed over the years. Because earlier they were kept in isolation, or they were socially segregated, or they were not talked about. But now this is an open book, and their participation in society, in schools, in colleges, in general kind of habitat is fairly open. Now, I feel that according to the times, the kind of crime, even psychological trauma, which is sometimes caused because of, let's say, people not being sensitized or not being sensitive, that part is still neglected. And also, I'm talking of, say, even up to 18 years, even sexual crime against them is often goes unreported. So
Yes,
that's one area where I
Yeah,
would
ma'am.
like to draw your
So
attention.
I also wonder that transgenders, I think, are in the society from time immemorial, since we are there. But fortunately or unfortunately, for the past 2 decades, the subject matter has been under consideration. They are being taken care. The law has come. Some of the public spaces are being created. So the subject is there. And despite that, we have not addressed that issue at all in the criminal law, at all in this Bharatiya Nyaya Sanhita. In fact, to the extent of definition, in the definition the term transgender have been defined, but later on none of the offense have been specifically. Yeah, so I feel many cases are pending in the court. Some of them have been decided where we are talking about their rights. So this should be taken care. we are pointing it out, maybe, hopefully it will be taken up. Thank you.
I think we can have the next question from the students.
Good afternoon, everyone present here. Good afternoon, honorable panelists. I am Aditya Gupta from third year. I am a third year law student from Lloyd Law College. So, my first two questions was, as mentioned by sir, why the offenses like adultery and bestiality and the crime against homosexuals is ignored by the new criminal laws? And other than that, I have two more questions. The first question is, why the punishments like murder and the aggravated form of murder like mob lynching and organized crimes have the same punishment as the murder? As even at the time of drafting of bills, the standing committee was of the view that the aggravated form of the murder, like mob lynching, should have more harsher punishment. And secondly, my question is, why the offenses like cheating and paper leaks, which are very serious in nature, are considered and mentioned in the petty organized crimes in this new criminal laws? That's all.
What is the punishment for murder?
He says aggravated form of murder.
What is the punishment for murder?
Sir, death and
What
life
can be the punishment for aggravated murder? It is already there. And the discretion has been given to the judge that depending upon the gravity of the offense, he can award life imprisonment, or he can award life imprisonment till remainder of the life, or he can award death penalty. It is the option for the judge. So we should not put everything in black and white. Let us leave something to the discretion of the judge also. What was your second question?
But sir, these both offenses will create a same kind of deterrence. Like
That leave it to the judge.
okay.
If it is mob lynching, he can give death penalty. If it is simple murder in anger, he can give life imprisonment. And then let me tell you, you must not be knowing, there is again premature release of these convicts. And there is a standing committee of the government whereby after serving sentence of 14 years, case of every convict is to be considered by the government for premature release. And then they have graded this punishment, that if it is this murder, it will be after this much year. If this is that murder, it will be after this year. So government has already taken care of that in that scheme. Your second question I could not follow.
So my second question was like offenses like paper leaks and cheating, which are very serious in nature, like the whole career of the students got affected by the paper leaks. Why these offenses are mentioned in the petty organized crimes?
Yes, that is a drafting mistake, and serious objection have been there, because they have said selling examination question paper. They have not qualified it whether it is question paper of last year, we all purchase and prepare in our examination, or it is for the future examination. They should have qualified it. So that is the mistake. It should have been clarified there.
Thank you, sir.
On the point you raised, there's a very valid point. In fact, if you see the original draft in the bill for mob lynching, although they didn't call it mob lynching, there was a provision for punishment of 7 years. Now the IPF memorandum pointed out that you are making mob lynching a lesser offense than murder. Yeah. Then they have modified it, put it both on the same thing. Now similarly, apart from this, there are other instances also. For instance, snatching. If you take snatching, the punishment is 3 years. For theft also, punishment is 3 years. Yeah. In fact, for the second conviction, an enhanced punishment can be given for theft, whereas that is not available for snatching. One more thing, interesting thing is, right of private defense is available to defend your property against theft and robbery. But right of private defense is not, snatching is not included in that category. So essentially, this snatching has been defined in such a manner that I would say snatching in BNS is like the appendix in the human body. It serves no purpose, whereas it can cause a lot of problem.
in this context, I would also like to say that a new provision, organized crime, has been added with the rider that for all these illegal acts, human trafficking, sale of weapons and all these things, if it comes under organized crime, if you are part of a organized crime syndicate, now there is no procedure as to who will declare who is a syndicate. How can you, what will be the evidence? How do you decide कि somebody is a member? Are you leaving it to the officer in charge dreams that he will say कि हाँ ये उसका gang का है, ये इसका gang का है. So this organized crime syndicate is a very open term used without any qualifying riders as to how will it decide which is an organized, what is the procedure. Like there are laws which details the procedure, but this is lacking here. But I would also, the same thing that he raised, I was also, while reading the text, found that if a single person commits a murder, he can go up to death. But then if you're doing it as a contract killing, and by the way, the contract killing is outside the purview of organized, there are a lot of, so human trafficking is also included. But contract killing, you're killing somebody for ransom, they are not covered in organized crime at all, whereas we all are aware that there are such rackets functioning. Thank you.
Just a minute, because I think we are running short of time, we need to conclude. We'll have last two questions, one from sir and one from ma'am. So first, ma'am, if you permit, first I can take him, but then we'll have, and that will be the last question, I think, because of the positive time. Yeah, please.
Yes, sir. So after hanging my boots, I'm now with Reliance Jio as a national nodal officer. And my team provides more than 5,000, 10,000 CDRs every day to the police. Now, till now, when 65B was there, we were giving one certificate. Now we have to give two certificates and along with the hash value and all. Of course, Shini made a bit reference to this CDR, but I want it to be elaborated. Who's the expert in this case, and who would sign this Part B of the certificate?
Sir had, in his remarks in the beginning of the day, referred to it, because the expert in 63 do not fit into any of the expert definitions that we understand, neither in 39 BSA nor the forensic expert as in 65 IT. I don't remember the section rightly, 79. So the expert, it requires clarification as to who that expert is. If you are referring, it cannot be a forensic expert for sure anyway, because as sir had already told in the morning, like I am from Odisha, there is not our facility, the State Forensic Science Laboratory, the cyber wing has not passed through this accreditation process, which is in the IT department, to be qualified a forensic expert. So if you look at there are references to in 329 BNSS also, where examiner of electronic evidence. So that will be the expert as per IT Act. But this definitely, because there are hundreds of not just CDRs, electronic evidence, for you it will be still limited. Imagine the kind of Part B certificates that have to come in all the electronic evidences seized by OCAM. Are there enough experts in each state to actually sign the Part B of the form? So this is something where there is an oversight in what that expert would be, and we would require that maybe in future this clarification will come or an amendment.
As I said, every day I'm providing more than 10,000 CDRs and IPDRs. More than 10,000 every day.
This is an area where nobody has really understood who that expert is.
Okay.
मैंने इसीलिए उसको रिजर्व रखा हुआ था, because I knew that would be. इस पे और चर्चा करेंगे अगले सेशन में, और थोड़ा चर्चा करेंगे. Now I'll request ma'am to ask her question.
So that's, I think, the final question. There's not a question really. First of all, for the student, benefit of the student who's sitting at the back and who had put in the question regarding cheating, UP, I think, has made amendments, and we are now having 10 years punishment for cheating, 10 years of imprisonment for cheating. So that is a recent amendment. But I am here to again reinforce and reiterate, sir, which I would say an ambiguity as far as the concern goes of anybody who's married 18 years and above. And if it does not have a provision of a rape in it, then I'd like to question as to what happens to the women every day who is, if not physically, if she's physically abused, you have a section for it. She's beaten up, you have a section for it. She's murdered, you have a section for it. But if she is through intercourse punished day in and day out, then what is the section for it? Let me give you an example of the French lady who was abused by her husband, drugged 50 years into marriage, drugged and raped. I'm not talking about the rapes by other men, but the rape by her husband. What section did you have in this country to protect her? And if that be so, I also question the forum. I think all those who sat and made this law were probably all men sitting there. हम लोगों को अगर जोड़ दिया होता तो ऐसा section नहीं आता. Thank you.
Very valid, pertinent observation made by ma'am. I think though paucity of time doesn't permit, but in case there is any student, only the student, and particularly from this side, we are, so who is that? Those who qualify the definition of a student, huh? Yeah, please. Sorry, ma'am. No, that we know, ma'am. That we know. Yes, please. हाँ,
मेरा
बोलिए.
क्वेश्चन ये है कि जब
हाँ.
स्पेशल प्रोविज़न बनाया जाता है, जैसे कि वुमेन्स के लिए बनाया जा रहा है या चिल्ड्रन के लिए बनाया जा रहा है, उसके लिए स्पेसिफिकली इसलिए बनाया जा रहा है ताकि वो वनरेबल है, उनके खिलाफ इजीली क्राइम हो सकता है, इसलिए उसको भारतीय न्याय संहिता में स्पेशली मेंशन भी कर रखा है. क्या पर्सन विद डिसेबिलिटी को मेंशन किया गया है? प्रोविज़न तो बना रखे हैं, RPWD एक्ट 2016 बना हुआ है प्रॉपर्ली, पर उसको कोई जानता भी है? UPSC के थ्रू क्लियर, मतलब पढ़ने के लिए तो पढ़ लेते होंगे, पर किसी को RPWD एक्ट 2016 पता भी है? मतलब राइट्स ऑफ पर्सन विद डिसेबिलिटीज़ के, मतलब अगर उनके खिलाफ कोई क्राइम हो रहा है तो उसका क्या होगा, उसके लिए क्या प्रोविज़न है? इस पहला क्वेश्चन ये है. दूसरा ये है कि जो क्या कहते हैं, मैंने सुना है कि कहते हैं जो अपना FIR है, FIR के अंदर अगर पर्सन विद डिसेबिलिटी क्रिमिनल है तो उसके लिए तो सेक्शन है कि वो पर्सन विद डिसेबिलिटी क्रिमिनल है, पर अगर वो है क्या कहते हैं विक्टिम है तो उसके लिए कोई ऑप्शन नहीं है कि पर्सन विद डिसेबिलिटी की एक विक्टिम है, उसका कोई वो नहीं है कि उससे ये होता नुकसान कि पर्सन विद डिसेबिलिटी के खिलाफ कितने क्राइम हो रहे हैं, वो डेटा ही नहीं आ पाता.
बहुत बढ़िया सवाल है आपका. क्या शुभ नाम आपका?
आशुतोष सिंघल.
आशुतोष, आपने मेंशन किया राइट्स ऑफ पर्सन विद डिसेबिलिटी एक्ट 2016 और
16.
उसमें बहुत सारी डिटेल्ड में राइट्स हैं आप लोगों के, एजुकेशनल राइट्स हैं और दूसरे प्रोटेक्शन के राइट्स हैं. उसके बारे में अवेयरनेस नहीं है अभी सोसाइटी में, और जुडिशरी अवेयर है. अभी जुडिशल एकेडमी चंडीगढ़ में इस पे एक सेमिनार हुआ था, बहुत ज़बरदस्त तरीके से डिटेल में भी हुई थी, बहस भी हुई थी, और नेशनल लेवल पे मैंडेट था कि आप इसको बताइएगा कि किस तरीके से इनको कवर किया जा सकता है. मैं आपको बता दूं JJ एक्ट में ये प्रोविजन है कि अगर विक्टिम जो है वो विद डिसेबिलिटी है तो पनिशमेंट 1.5 है. तो वहाँ पे विक्टिम का राइट क्रिएट किया गया है, लेकिन जो जनरल लॉ है, BNS है या दूसरा लॉ है, उसमें डिस्टिंग्विश नहीं किया गया है राइट टू पर्सन विद डिसेबिलिटी. लेकिन जुवेनाइल के केस में वो है, पनिशमेंट इनहांस्ड है इफ द विक्टिम इज पर्सन विद डिसेबिलिटी.
Unsound mind, a type of person who is having some type of disability, but regarding any physical disability or the disability as defined in Right of Persons with Disability Act 2016, you are right, it is nowhere. The ambit can be increased with regard to offenses committed against the persons with disabilities. Agree with you, this require attention.
Can you hear? I think this consultation on disability, especially vis-a-vis children, is going on. And I remember when there was a session in the High Court in my state, I tried to find out from the data that we have as to how I just wanted to know what are the difficulties the people with disabilities as victim face when they go to a police station. And the data was absolutely missing. We had, as part of the consultation, suggested that in the IIF form, there has to be a drop-down menu where you will have an option to click mark, like you are capturing the data of the child now, which was not there earlier. It's time that we actually capture the data with respect to people with disability. And it's a very valid point raised. And we have already put that as a recommendation from the Odisha High Court Juvenile Justice Committee. Thank you.
Thank you. I'll end this session by thanking my co-panelists, the panelists of this panel. They were very elucid, I think, in their responses, their observations, and making the opening remarks. And I think we had a very wonderful session, though because of the paucity of time, we had to cut it short. Thank you so much. And yeah.